I am a legal support coordinator at VIP, and I handle mainly family law cases. Today, I have with me my supervising attorney, Denise Lynch. She also handles family law cases, and we are going to be going through a training. Mr. Lee Schwartz and Megan Watson have very kindly agreed to be our trainers today. Lee is a partner at Schwartz, Fox, and Saltzman, and Megan is a partner at BKW Family Law. Both of our trainers have been volunteering with VIP for a very long time, and they are very well experienced on how to handle our custody cases. So before we get into the custody training, I wanted to give some information about family law and custody cases in the city of Philadelphia. So Philadelphia is currently considered the poorest big city in the United States. And there is a higher demand for free legal services than there is our ability to keep up with. VIP's volunteers really play a crucial role in bridging that gap between the demand and the supply that we can put out to assist clients. VIP also consistently does have a need for custody volunteers. The data on this slideshow shows that much like the city, we have more requests for custody assistance than we can actually help with. And clients that go alone to family court often are navigating a system that's difficult to understand. It isn't made for someone without an attorney to understand. So our clients really do benefit from having a volunteer attorney there in their corner with them. Something that I like to let people know are VIP's expectations of our volunteer attorneys. Volunteers are not required to represent a client for every single hearing that they may have. We prepare clients to know that their volunteer is only assisting them with the single hearing that they came to VIP for help with.
And Susan, can I jump in on that? And like, especially in family law, we recognize that this is an issue because we all know, custody cases can go on forever, right? They can start unfortunately, when a child is an infant and go until they're 18. So it's really important to know that it's okay to just come in for one case. You can, of course, choose to stay if you want. And Lee and I have done that, but really just one hearing, one conference is just even helpful to the client.
Absolutely. And if it ever were to come up that a client asks you to represent them beyond the initial hearing, you're always welcome to reach out to someone at VIP and let us know that that request has been made if you're unavailable, and we can handle talking the client through that. If there's nothing pending, a volunteer attorney can withdraw their appearance. So just talk to anyone at VIP about that if you want to know more. I am going to turn our presentation over to our trainers today. So Lee, Megan, I will let you handle the rest.
Let me just say hi first. I am a partner at a family law firm. We only practice family law work, and I am very happy that you guys are all here. I'm going to give you my information because I'm also very open to having conversations. And if you take a case, serving as a mentor, helping you answer questions. So my email is mwatson@bkwfamily.com, mwatson@b as in boy, k as in kid, w as in water, family, all one word.com. And my phone number is 215-790-8800. And so if you take a case, which we're hoping that you will do by the end of this presentation, you can always feel free to contact me, and I'm happy to provide any assistance.
And I'll introduce myself too. I am also a partner in a family law only firm in Philadelphia, Schwartz, Fox, and Saltzman. I've been doing this stuff for over 40 years. I've been with VIP for over 30 years. And as with Megan, and Megan's firm, she knows how I feel about them. They really are all that. and their dedication to pro bono is as high as it can be, and it's the way we all should practice, and we try and follow in their footsteps. I likewise am open to mentoring and taking calls. My email is my initials, LAS at S as in Sam, F as in Frank, S as in Sam, attorneys, plural.com. Reach out and be happy to chat with you. And our phone number is 215-967-9070.
I am putting my information in the chat because somebody asked me to do that. So actually that was a good call.
Good.
All right. Okay. Custody. I'm not sure how many people on here have any familiarity with custody. The bottom line question that every judge, hearing officer needs to answer is what is in the best interest of the child or children in front of them, period, end of story. I will not give you my view that I think our laws are not child-centered enough. We won't go into that. They are, but it's supposed to be entirely child-centered. So, so there are factors that are listed at section 5328, which should be on pages 23 and 24 of your manual. I'm just going to turn there and make sure that those are the right page numbers. No, those are not the right page numbers. Where's the statute? All right, I will find what page numbers all the factors are listed. And so a judge is required, or a hearing officer is required. It's oh, it is page 23. Sorry, I was looking at the other 23. There are two. Got it. It's page 23. Yes, sorry. Those are the factors that a judge has to consider, and a judge is required actually to either enumerate them on the record or to put them in a written opinion when making a decision. So some of those factors, if you're looking at your manual, are which parent is more likely to encourage contact between the child or children and the other parent? Is there a past history of abuse? Which parent is performing the parental duties, such as, and yes, we take testimony on things like laundry and driving to school, and who's going to parent-teacher conferences. Are there other children, other siblings or half siblings? Are there extended families? What a child's preference is, and we will talk a little bit later. I'm going to hold discussion for that until we talk a little bit later about judge interviewing children. Which party is more likely to meet the needs of the child, how close the parents live. So those are some of the factors that are on page 23 of your of your manual and in the statute.
And the factors are really the framework of what you want to elicit from your client when you take testimony. So you're going to look at the factors. You're going to go over the factors with your client. We email them to the client and ask them to write down, the skeletal facts that they think are important to prove each point. And then you'll fill that in when you talk to the client. And that's really the framework of your presentation in front of the court. Now, that's also the framework for cross-examination when you're asking questions to the other side, because sometimes certain factors will favor your client and certain factors will favor the other side. But that really is the framework for cross-examination and direct examination.
And that's a great practice tip. We do the same thing where we share the factors with our clients, and I will ask them to put down where they think they fit into each of those factors. I will also ask them what they think the other side would say, because that also helps me with cross-examination and also potentially preparing any weaknesses in my case. So, so it's a good way to kind of get the big picture from your client and to stay focused on the factors and stay focused on the child. Lee, do we just want to do we just want to switch screens? You want to take this one?
Yeah, sure. So a child is any unemancipated human being under the age of 18 years of age. Once a child reaches 18, custody determinations stop for that child. Physical custody is the actual physical possession and control of the child, as it says, and we're going to talk more about the different flavors of physical custody as we get through this. Legal custody is the right to make major decisions on behalf of the child, including medical, religious, educational, and other major decisions. And generally, legal custody is shared between the parties. However, there are many different flavors of that, which we really don't need to get into today in any depth. But that's the difference between physical and legal custody.
So specifically, the types of custody break down a little bit further. So with physical custody, you have sole custody, which means one parent has custody 100% of the time. Even if there's supervised physical custody, that other parent that's not supervised, the parent that has custody the rest of the time, is considered the sole custodian. And the other parent either has nothing or would have supervised custody, which literally means short periods of times where they're supervised. Then there's shared physical custody, which is literally 50-50. It is 7 overnights in a 14-night period, 14 overnights in a 28-night period. It is a 50-50 schedule. And so just be advised that a lot of clients actually come to you and say, I want shared physical, but they don't actually mean 50-50. So they're using that term, but as it's defined by the statute, that's not actually what they mean. What a lot of clients who say I want shared physical custody mean is they really just want partial. So primary and partial go hand in hand. Primary is if a parent has more than 50%, more than 7 overnights in a 14-night period. And partial is for a parent who has less than 7 overnights in a 14-night period. And it could be 8 and 6. But that's where that's the difference between primary, partial, and shared. And so when you have a client coming to you saying, I want shared physical, I always flush out with them, okay, what does that mean? Well, what are you thinking about in terms of a schedule? Because for our legal terms, we have to define them legally, even if it's different than what the clients think the terms are. The legal custody, as Lee had said, is the right to make major life decisions. The day-to-day decisions about what a kid eats and wears and stuff is not legal custody. Legal custody is schooling, medical, religion, like what religion the child's going to be raised in, where the child should go to school. Those are the legal custody issues. And typically parents have shared. It is very rare that one parent has sole legal custody. That comes about if a parent, in extreme circumstances where a parent is unable to make decisions, maybe where a parent might be extremely abusive. And what's interesting in Pennsylvania is there really is case law saying that you can't have a tiebreaker rule, but some judges do that. Although there is case law that says, if you are giving a parent a tiebreaker rule, for example, shared legal custody, but if the parents can't agree where the child goes to school, mom gets to make that decision. That is not actually shared legal custody. That is giving mom sole legal custody with regard to education. And that does happen sometimes. If the issue in your case is exclusively a legal custody issue, I would say reach out to Lee or I, but it is possible to get legal custody on one specific issue. I would say probably passports are actually a pretty common area where I've gotten sole legal custody, where the court will give sole legal custody to a client to get a passport so that they can go ahead and do that. It's probably the most common sole legal custody I've seen. I don't know about you, Lee.
Well, you also might see it where the child has an allergy, for example, that might be life-threatening or serious, and one parent is willing to treat for it, the other parent doesn't believe it, or wants to try some other non-standard medical way of treating it, and the child keeps getting a reaction. The parent who won't acknowledge it probably will lose legal custody with regard to medical treatment for the child. Just so you know, somebody calls you, and I get it all the time. I know Megan does too. Somebody calls, first contact, and says they're looking for sole physical custody. The hairs in the back of your neck should stand up because it's kind of very rare. And really, you want to talk to them and say that unless the other parent is dead or is psychiatrically disabled, meaning not you think they're crazy, but psychiatrically disabled, or some has some real impediment to caring for the child. I mean, Megan and I have both had clients who are in wheelchairs and who are, paraplegics and who have real physical infirmities, but can care for a child. So you've really got to explore with the person that's saying that what the facts are and why they think sole physical. And they explain to them that it's very rare. They may say, well, I really don't mean that. I just think I should have most of the time. Okay, that's fine. Now explore that. But sole physical is as uncommon as sole legal. They're both on the very ends of the spectrum and need to be explored by you.
Yeah, incarceration is probably the only other thing I could think
Yeah.
of where a parent might get sole physical.
Right, right. So maybe getting a little bit deep in this thing, and if you have a case where there may be jurisdictional issues, you need a mentor, whether it's Megan, whether it's me. We have a lot of really good family lawyers that volunteer for VIP. Don't guess. Get a mentor. We love talking, as you can see, and we gab, but between Megan and I, you've got 60 years, almost 70 years of experience. So take advantage of it. We're happy to help. But under the law, the UCCJEA, which is a unified statute, the court has jurisdiction over a child, custody matter if the child has resided in the court's district for at least 6 months, 6 consecutive months. And you'll see people will come into your office where they just moved here and they want to file for custody. You have to explore that and explain that. But before you explain, get a mentor. Objections to venue or jurisdiction need to be raised by preliminary objections. Check the Pennsylvania Rules of Civil Procedure, look up preliminary objections, and preliminary objections are to question a number of different allegations or pleadings in a case, and they need to be filed within 20 days of service. So if you've got something you want to object to, again, get a mentor, and also check out it's not under the divorce custody support, but it's under the general rules of civil procedure. And it's very readable, it's very understandable, but you still should have a mentor.
So who is allowed to file requests for custody? Clearly a parent can, and a parent has the ability to ask for any kind of custody, partial, primary, shared. A person acting what we call in loco parentis. So that's standing in the shoes of a parent. I like to explain it to my client what that means. And in order to qualify as being in loco parentis, that individual has to have assumed the parental status and discharging the duties. So basically, if the child has been living with them and they have been doing everything that you would expect a parent to do, right? Taking them to school, making sure they're bathed, feeding them, signing them up for activities, all those normal stuff. They've met the first 2 elements. The third element, it has to be with the consent and the knowledge of a parent. So the parent needs to know that this person has custody of the child, is taking care of them, and is doing this, and they have to consent. I have actually had issues where that has been the question, is whether a parent consented to or not. So just because a child lives in a household doesn't mean that someone is in loco parentis. For example, if a parent is also living with someone in the household and the parent is still the one performing all the parental duties and that other person's not doing so, they're not ILP. So living in a household alone doesn't meet the standard. You have to delve deeper into what is that individual doing for the child as it relates to parenting the child. So those are the questions that you need to ask if someone says to you, okay, I'm not a parent, but I want to sue for custody. Susan, are we taking questions in the chat? I just wanted to double check.
Sure, we are, great with stopping if someone has a question.
Okay. All right. So just so everyone knows, if you want to put your questions in the chat, I'll keep checking that. And we can interrupt and answer questions.
Megan, I'll keep an eye on it and I'll let you all know if you have questions.
Okay, thanks.
So the in loco parentis question that Megan so artfully talked about and the grandparent standing, custody in those areas is very much fitting a round peg in a round hole. You've got to check the statute. It appears complicated when you first read it, but it's very logical, and you got it. So, for example, a grandparent not in loco parentis, so a grandparent like me who has grandchildren, but I don't live with them and I don't discharge parental duties. I just always say yes. So that's not a parental duty. But a grandparent not in loco parentis also can establish standing, but again, round peg and round hole. You can sue for any form of custody if the relationship began with the consent of a parent. So you've got a history of seeing the grandchild with the consent of a or both parents, and assumed or is willing to assume responsibility for the child, and the child is either adjudicated as a dependent by the court or substantially at risk of abuse or neglect, or the child resided with the grandparent for 12 consecutive months. So you've got to really explore the facts with your client and see if those facts are in play. Again, mentor, at least in the beginning. I think it's just critically important. Now, that was the sue for any form of custody. A grandparent can sue for partial custody, partial physical custody, if the parent of the child is deceased. That gets you in the door. Or parents have started a custody action and don't agree about the grandparent contact. So again, all standing says is yes, grandparent, you can get in the courthouse door. Establishing standing doesn't mean you have a schedule yet. Once standing is established, then you're in the door. And a lot of grandparent cases are filed, but don't fit the round peg in the round hole. And grandparents don't get standing, and sometimes it's factually tragic when you have a grandparent doesn't get standing because they may not see their grandchild, but that's what the statute says. So you've got to, have it printed out in a folder. Printed. I mean, that's the way I do it. But nonetheless, you've got to have it available to you when you start discussing grandparent standing.
So there has just been a relatively recent addition to the statute to allow for third-party standing. And this was the attempt by the legislature to address kind of, I think, the change in kind of how families operate. And so if you are a third party, so you are not a parent and you are not a grandparent and you are not in loco parentis, you have standing to file for custody if you have assumed or are willing to assume responsibility for the child, if you can show that you have a sustained, substantial, and sincere interest in the welfare of the child. So not just, a neighbor who is, has known the child, but you have to show that those are very important: sustained, substantial, and sincere interest. Neither parent has any form of care or control. So they're incarcerated, they've disappeared, they're not around. Neither parent is around. And it's important to note, this does not apply if there's a dependency proceeding in play. So if the child is already the subject of a proceeding on the dependency side, is involved with DHS, then this third party standing does not circumvent that proceeding is what is going forward, and the court and the dependency side is going to make the decision. And a party cannot come in and try to circumvent what's going on there by filing for custody. So sustained, substantial, and sincere, again, you need to be having those conversations that people say that that they want to file for custody. You have to find this information out. I will tell you, I have a case years ago that would have probably fit into this category. This didn't exist then. I had an aunt who, her sister was ill with cancer. She had done a lot of care of the child, and was taking care of the child. And but the child was still living with mom, but aunt was coming in regularly and doing what needed to be done because mom wasn't able to do it. And I could not get standing for that aunt for custody because there wasn't any avenue. Now, I say maybe because the question was dad. Dad in that case had not been involved with that child, but we weren't sure what was going to happen when mom passed, which we knew was going to happen. I would have liked to have had this, so I could have made that argument, but at the time I just wasn't able to get aunt in to have any form of custody of that child.
So it's incredibly important for you to speak with your client regarding whether they or anybody in their household has any criminal convictions, because there are a number of criminal convictions which can have a substantial impact on custody, depending on how close in time they are for relatively minor criminal convictions of this sort, or how serious they are, which may not matter how far back it occurred. So if a party has, and again, check the statute, it just lists the enumerated offenses. So if somebody's got a DUI that's 15 years old and had nothing since then and hasn't had any alcohol related incidents since then, probably doesn't have much of an impact on custody. But if somebody's got 3 DUIs over a 3-year period, and the last one was 4 months ago, you may have a problem there with that person. So it's not just your client, but it's anybody that resides in the household with your client. You got to have that conversation. The court can order an evaluation of that party, probably will in certain cases. I once, not to tell war stories, but a number of years ago, had a client who had been convicted of murder 20 years ago before the custody matter and wanted some custodial time with his child. And I went out, the client luckily had the resources. I went out and hired a psychologist who did an evaluation, and we brought it with us to court on the day of the hearing. And we're able to, because of a number of factors, which I'm not going to get into, obtain a custody order for this gentleman who had been convicted of murder. But murder may knock a number of people out of the box generally. So it's certainly worth it to know the enumerated crimes, enumerated offenses, and to speak with a mentor, because that kind of gets you into an area that you really ought to have a little bit of guidance.
Those offenses are on pages 24 and 25 of your manual. But as Lee said, the time is also going to matter, because I have had judges, I have had someone, maybe one of the lesser enumerated offenses, from well before the parties even had a child. And the judge will say, but you chose to have a child with this person knowing the offense, what they had done previously, and have determined that therefore there's no risk because the parent themselves made a decision to have a child with this person who had been convicted of whatever it was, like years prior. So the statute also requires the court to consider whether there's been any DHS in Philly or children and youth involvement. If either the party or someone in the household, again, it's not just the party, not just the parent or the person filing, but anyone in their household has been identified as a perpetrator or found to have committed child abuse. And also to consider if there are services being or have been provided by children and youth or DHS. So that is specifically even identified outside, in addition to having to consider the enumerated offenses.
And if there is DHS involvement in your case, or there has been, they can be an important witness to your case in a custody matter, and you're going to want to contact DHS. There's a procedure to do it, to subpoena the records and subpoena the caseworker. And again, just, cut to the chase and talk to our mentor. It's not difficult. You just need to know how to do it. Relocation. Relocation is when a parent seeks to move with a child of such a distance that will have a substantial impact on the custody rights of the other parent. And substantial is important. And it doesn't matter whether you have a custody order in place or not. If somebody contacts you and says, I want to move, there's a lot of questions to ask. And the issue is where the party's moving, number one. So if you've got a party that lives in far northeast Philadelphia, for example, and the other party wants to move to very lower Bucks County, that may or may not be a relocation because it may be 10 minutes away. I remember as a younger lawyer, it wasn't younger, maybe 15 years into this, I had a case when Judge Ford was first on the bench. And it was a case where the one party was moving to Ballackinwood. And I thought it was a relocation. I came in all hot and bothered and ready to prove this case. And Judge Ford looked at me and said, "You move 15 minutes away." I said, "Yeah, but it's in Montgomery County." She said, "So what?" So you got to use common sense, which I did not use at the time, in order to just determine whether or not it's relocation. And that can be a complicated question with a judge. You may go in a case and a judge may say to you, "Ms. Watson, is this really a relocation?" Or you tell me why it is a relocation, or you tell me why it's not a relocation. So you've got to be up on the law, and it really takes some pause on your part. If it is a relocation, there are forms that need to be filled out and filed with the court in order to effectively put the other side on notice that the party wants to relocate and give them an opportunity to object. And that's all in the custody statute. The form is in the custody statute. The court has the custody statute. It's easy to find. But relocation is an entire hornet's nest in and of itself. It's academically fun. It raises a lot of questions. There aren't necessarily all the answers. And it's an area of law that Megan and I are involved in all the time. It's very fact sensitive. It's very expensive to litigate because it takes a lot of time to make your case, get the facts. And I think it's a lot of fun. I enjoy relocation cases. Megan, I know you have things to add to what I just said.
Yeah, I mean, I've done a bunch of them. They're not, it's as Lee said, very fact sensitive. Relocations more often are not granted than they are. But as Lee said, there are, I've had cases where judges have said to me, moving from Philly to Cherry Hill is not a relocation. My issue with that becomes school. Because if there's going to be a change of the school, you either need to treat that as a relocation or you have to file a motion exclusively about school, because a parent cannot unilaterally, if the parties have shared legal custody, you cannot change a child's school without either agreement of the other party or a court order. So if a parent is moving from Philly to Cherry Hill, but is going to continue to drive across the bridge every day for that child to continue to go to their school, that's one thing. But if the expectation is they're moving to Cherry Hill to switch schools, I will always have them file a petition of some sorts, either a relocation or a petition about school.
Megan, we do have one question in the chat.
Oh, yeah.
It just asked if underlying custody matter is necessary to file a relocation pleading.
Yes, what's going to happen is the party that wants to relocate is going to do the notice of relocation, file it with the court, and if the other party doesn't object to the relocation or indicates that they don't object or doesn't file the objection, you can then proceed in the custody matter in order to obtain an order. If the other side objects, you're going to want to file a petition for custody because you need a custody determination. And what you're hearing today is you may have thought coming into this that custody was this singular, simple area of who's the kid going to live with? But there are so many sub areas of custody, like relocation, like school choice. School choice can be a massively complicated question that may involve just the clients testifying, may involve a school expert to come in and testify, may involve testimony of a psychologist. It's a sub area that school choice that is also something that takes a lot of time to develop.
So Mark, just to specifically, I think what you're saying is, do you have to do, like when you have an expedited do you have to have an underlying and an expedited like you do with expedited? Not necessarily. It's not like you have to file a petition to modify and a petition for relocation, but you need a petition filed. And so that's sometimes that's done by the person objecting. I have certainly done that. As the person objecting to the move, I have filed a petition to prevent relocation. But obviously there needs to be some underlying petition filed so that the court can address it. It's not just the notice. Okay, so if you have a client who's come to you and says, okay, I want to file for custody, you have to file a custody complaint. There are forms in there's both modification forms and original forms in your manual. Everything is filed with the clerk of family court, which is at 1501 Arch Street. The rule sets out what it looks like, but like I said, there are examples in your manual. You have to file the original plus 5 copies. There are additional forms that as a VIP volunteer lawyer, you will add so that the court does not charge you the fee that goes along with it normally. There is a domestic relations information sheet, which gathers the information about the both parties, confidentiality sheet, because we have a requirement to keep names of the children confidential. So actually, I will say in our pleadings, we pretty much these days are just using initials and not names. And then your client also has to complete the criminal and child abuse verification, which I still think is it's a confusing form for people who are looking at it for the first time. So that form, if you want to take a peek at it, starts on page 16 of your manual. So with this form, if your client and no one in their household has been charged or convicted with any of these crimes, you don't do anything but sign it. There's nothing to mark. There's nothing to write. You're only supposed to mark it if you have been charged or convicted of these crimes, which I think gets confusing for people who are filling this out.
Well, it doesn't say that. That's the problem. It doesn't say that. So, I mean, we know that as practicing lawyers,
right?
But laymen look at it and go, what do I do with this thing? So it's just, you're right. It's confusing, Megan.
Yeah, it's very confusing. So if none of these apply to your client or anyone in their household, you're just going to have them sign. And then you attach it to your custody complaint. And the court will not schedule a hearing unless you have submitted this. So you have to submit the criminal verification. You have to submit the domestic relations information sheet. And you're going to obviously submit the certification of no fee so that you don't get, your client doesn't get charged.
And if you're suspicious that your client is not being honest with regard to their criminal background, just tell them that the court routinely, every case is going to run a criminal background check themselves on the litigants and see whether there's anything there. So not putting it on there and then having the judge find out later is a bad start to your custody case.
Yep. And then in your wherefore clause, where you're asking the court what you want, it's very important to be specific, right? You want to identify, do you want shared physical and shared legal? Do you want partial physical? If you want partial, what is it that you're looking for? I mean, be as specific as you can in the wherefore, which is a little bit different than the facts. So in a custody complaint, the facts are who the parties are, where they live, where the child has lived for the past 5 years. You do not have to put into a custody complaint everything that you want to present at the hearing. You don't have to create an enumerated list of everything that you think the other parent has done wrong. That does not go in a custody complaint. That you save for the hearing, you save for the pretrial memorandum if a judge requires it. But the wherefore clause is important because the other party has a right to know what you're asking for.
So the intake unit for family court is located on the 8th floor. You can walk in any day. You don't need an appointment and begin the process of filing for custody. There's a help center on the 11th floor of family court. It was originated by the court with the assistance originally of the family law section. Now public interest lawyers really have kind of taken over the family court help center. It's open Monday to Friday, 12 to 3. Family law section lawyers still volunteer to work there. And what goes on there is it's a place to help pro se litigants complete the appropriate custody forms in custody cases to get them filed. It really does great work, and it's a good place to send your clients just to begin the process if you choose to do that. We do our own petitions. Megan does also, but it's really for pro se litigants who don't have lawyers. But you can go there even if you have a lawyer. And then there's a website, which is right there, where a lot of forms are located in order to begin and modify custody orders. Begin getting an order and modifying one down the road.
And I will say, I think most of the cases that come to VIP, so that would be coming to you, have already had that initial filing. So either you have someone that already went to the help desk or the intake unit has already filed pro se, or they are the defendant, the other party, and someone has filed about custody and they're coming to VIP. Through VIP, I don't think I've ever had a case where it's like starting from scratch. So the initial filing is most likely to have already happened before a VIP client comes to you. Okay, so the first listing is a listing before a hearing officer who is a lawyer. So after an initial modification complaint or an initial complaint is filed, a court date comes out and you're scheduled before a hearing officer. Now, hearing officers are not judges. They cannot make final decisions in cases where primary custody is disputed or where a party is asking for shared custody. They can issue recommended orders. And they typically do. Lately, they have been issuing more recommended orders than they have in the past, just because of how far out our judge dates are. And they, particularly clients who don't have an order in effect at this time, they will issue a recommended order so that there's not children out there flailing without having schedules for where they're supposed to be when. Record hearings are usually that's when the parties agree that one of the parents has primary or one of the parties has primary physical, and the only question is what the partial custody should look like, partial physical should look like. Then there is testimony that's taken, record hearings, and a recommended order could be entered. Otherwise, in most cases, these hearings are treated as conferences. Where the hearing officer is really trying to work with the parties to see if they can get an agreement negotiated or partially something agreed to. So, for example, can they get an agreement on what the weekend schedule looks like, or do they have an agreement on holidays? And then they'll get an agreement on as much different issues as they can, and then issue a recommended order. Usually, lately, they've been doing that on what's not agreed to.
And also, don't be afraid to get to court a little bit early. See if you can find either the other party or their lawyer and try and work something out. Be aware that when both parties are seeking primary custody, nothing's going to happen that day before the hearing officer, except you're going to get a trial date. And if you can at least work out a temporary arrangement where both parents have access to the child, that would be awesome, because sometimes one parent has 100% because there's no custody order. So try it. I mean, I've worked out arrangements with pro se litigants, and just be friendly and nice, and try and sit down with them and have a conversation. Don't be a lawyer with a pro se litigant. It's just you're going to turn them off, and see if you can have a conversation and see what you can work out. Sometimes you can, sometimes you can't. Doesn't hurt to ask.
Yeah, and I think I'm probably have already skipped ahead to the next screen. But so at those conferences, like I said, when the hearing officer is trying to get the parties to agree on as much as they can, when they issue these recommended orders, identifying what's agreed to and what's not agreed to, you can still end up going to a judge after the fact. You can make that request, and they will schedule you before a judge if there's not full agreement on all the issues. Oh, the last two things. So the hearing officer can request a judge order drug and alcohol testing, which is done in the court. I've never had, and counseling for the child. You can make that request too. And then also a protracted hearing, and I think we talk about this later, but I'm not sure. A protracted hearing means that you know that your case is going to need more than the normal time allotted for a hearing before a judge. And so you have to file an extra motion asking for a half day or a full day. But I'm pretty sure we address that later on. So I'm not going to spend too much time on that right now.
Talk for just for a second, if I can, Megan, about drug and alcohol testing. You're going to have a couple of months generally between the time you file the custody petition and the time you get to this point. You need to talk to your client about whether they are doing drugs or, smoking dope, whatever. And you got to tell them, this is an attorney-client relationship. You're not telling anybody, but you need to know, because you need to tell that person if the other party in your custody case did drugs with you when you were together and you were happy, or knows that you smoke pot every night, you got to stop, because you may be tested when you go to court. And even though you tell them that, a large percentage of them still continue to do what they want to do anyway. But the point is, you need to at least advise them of that. It's a conversation you need to have on day one. And just advise them if they get tested and they have a problem with drug test, that it can impact custody.
And, pot's an interesting conversation, because although it's not legal in Pennsylvania recreationally yet, I really find that judges' attitudes have adjusted to that, and they're treating it this more kind of the same way that they treat alcohol, which is the use of pot interfering with a parent's ability to parent a child. So are the levels so off the chart that it's clear that they're not able to function? Are they doing it when they're with a child, when they're supposed to be supervising a child? But I'm really seeing that marijuana is being treated very similar to alcohol, versus the other drugs, which are just big no-nos. But and that's the experience I've been having lately.
Yeah, we have one judge in Philadelphia County who is pretty stern about it. Most of them are not. But again, you're not in front of a judge here. You're in front of a hearing officer. You don't know who the judge is going to be at this point before you get there. You'll find out that day, unless the computer's down. And I just urge them not to do it. And I think that, but I do agree with Megan. The attitudes have definitely changed regarding pot. It isn't what it used to be. So the reason it says hearing officer is called a custody hearing officer is because we used to call them something else in the past, which I still stumble on sometimes, which we don't anymore. And it doesn't really matter. Just call them custody hearing officers. If there is a record proceeding, it's theoretically conducted pursuant to the rules of evidence and the rules of civil procedure. I think it's a little bit looser than if you're in front of a judge. Your client and any witnesses, and there generally are not witnesses at a hearing officer level hearing. Generally, it's just the parties. The children are not going to be heard, except in the most unusual case where you've written a letter ahead of time and gotten special permission. And there's direct and cross-examination, that's for sure. The hearing officers have a 45-minute time slot. If you think it's going to be longer, you can notify the hearing officer ahead of time. Sometimes they'll give you more time. Sometimes they won't. Some of the hearing officers, when they get to 45 minutes in the middle of a sentence, they just stop you and they reschedule for another day. So just understand your time limitations.
So decisions from the hearing officer, as I've kind of already said, are issued as a proposed order, and you can file exceptions to that. So if it's a record hearing, so that a decision from a hearing officer is pursuant to the rules, because it's only about like partial custody, you would file exceptions to that report and within 20 days, and that would go before the exceptions go before a judge. If there are no exceptions filed, then the proposed order becomes the order. If there are exceptions filed, the proposed order does not become the order. That's a little bit different than support, if any of you does support work, because in support matters, a proposed order becomes an order even if you file exceptions. In custody, it does not.
So the exceptions hearing, and there's not a lot of exceptions filed to custody recommendations. There's some, but I don't think that's is as much as support. These hearings are scheduled before a judge. It's just oral argument. You're not having a custody trial. You're just going to tell the judge why there was an error of law or a major error by the hearing officer. The judge will only consider issues raised before the hearing officer. So what does that mean? That means it's prudent to order a transcript of the hearing, if there is one, before the hearing officer, if they had a record hearing. There's no cost for VIP cases. You can forward a petition for a certification of informa pauperis, and there's no cost. You can get the transcript. At the hearing, generally they don't take them under advisement. The judge will either grant or deny the exceptions, and if the exceptions are granted, they'll send the matter back before the custody officer to rehear or hear those issues. So just know that, and the time for things in family court is very long. So may take you 2 months to get in front of the hearing officer. Exceptions are filed. May take you 4 months to get in front of a judge on the exceptions. You prevail. You go back in front of the hearing officer. May take you 2 months to get there. Another order is entered. That becomes the order of court. You're 10 months to a year out, and you haven't even gotten in front of a judge on the issue yet. I'm not saying you shouldn't do it. I'm just saying that you need to understand the effect of filing exceptions, because if the order is not what your client really wants and they can live with it, it may be better just to follow the order and get in front of a judge on the temporary order, and that becomes your custody case where you can advise the judge why the temporary order is improper through your factual testimony.
Yeah, and I just kind of want to be clear. The reason I think exceptions are not filed regularly is because the hearing officers are not doing a lot of those types of specific cases where they have that authority to issue those orders. Now, like I said, they're issuing a lot of interim orders, but they're issuing them on cases under what's called exigent circumstances, which means there's a reason that they think an order needs to be entered now before the parties get in front of a judge. And lately, a lot of that has been there's just no order in effect, or because the time is so long and there's a specific issue that has come up that needs to be addressed before you can get to a judge. So in those cases, when they are issuing orders based on exigent circumstances, judges are signing off on them right away. And there's no filing of exceptions. That's your order until you get your judge date. So at that custody conference, you're getting a date for a judge already because the custody hearing officer knows that there's no agreement. You're getting a date for a judge, and then he or she may issue an order under exigent circumstances, which does become your order between then and when you go in front of the judge, whatever your judge date is. And this is your regular judge date,
Right.
right? You have regular hearings and you have trial hearings. If you're not protracted, and again, we'll talk about that in a second, you're getting either it's 30 to 45 minutes supposed to be, or you could get an hour and a half. Actually, I think this is off a little bit because it's either do you have one slot on their list or do you have 2 slots on their list? And I will warn you, a lot of times judges just start adding cases. So if you're just scheduled for one of these regular or trial listings, don't expect to have the judge's undivided attention for the whole morning. It just doesn't happen. There's such a need in Philadelphia County. There's so many cases. And then these go super, super, super fast. So if you have anything that's a little more complicated, or you need a judge to pay greater attention to than 30 to 45 minutes, then you want to file for a semi-protracted or a protracted hearing. If you're going to go forward with a regular or trial listing, you better be very directed in terms of the issues that you want to talk about. Some judges will give you that time. Some judges, I have a friend who was in front of a judge and she was there until 6 o'clock at night the other night, but they're not supposed to do that. But so just be advised that there are other people, other cases on the list, so you may not get as much time as you want. So be prepared if you are on one of those lists to walk in there and be very focused.
And you can't walk in that morning and say that you want extra time or you want a protracted date. This is a petition you have to file ahead of time, asking either for a semi-protracted or a protracted listing. And you can't do it the week before either. You've got to kind of do it at the beginning. Like Megan said, you've got to honestly analyze your case. And if you can't get it done in 45 minutes or an hour and a half, remember, you have direct, you have cross, you may have witnesses, a direct and cross of two people, mom and dad, generally. You got to look at it and pick up the phone if there's a lawyer on the other side and say, yo, we're not going to get this done. Let's file a petition. And generally the other lawyer will agree because they know you're not going to get it done. So you've got to make that assessment pretty early on in this.
Yeah.
The only one
We have
doing it is
another
somebody-
question from the chat. It's a brief one. It just says, how do you know whether the case is a hearing list case or a trial list case?
I have my staff call, to tell you the truth. I can't always tell. You can't really tell from the notice. So we'll just call over there and ask how many other cases are scheduled for the list. What does the computer say it's listed for? That's the only way I can find out. You know if it's semi-protracted or protracted because you will have a separate order that says it's scheduled for semi-protracted or protracted. But if it's just the regular notice, we'll just call and check.
So protracted matters or at least one full day. And if you're lucky, one full day will begin between around 9:30, I guess. You'll have a lunch break, and then we'll generally break at 4 or 4:30. It can be more than one day. You've got to be really lucky to get 2 days in a row or 3 days in a row. It does happen in Philadelphia. A lot of that comes down to it may not happen in your first case in front of a particular judge. You know, when Megan and I walk in together in a case and we tell a judge it's going to be 3 days, we're honest brokers and we've done this for a long time and they know that we know what our cases are going to take and they will try and get multiple days in a row. But it isn't uncommon to have a day in November, a day in April, and a day in January. I've got an annulment case that's over 3 years right now in days. And that's weird. That's very unusual, but I'm just illustrating that it can be really blocked out a lot. A semi-pro is a half day, semi-protracted is a half day. So you've got to be honest in your assessment with the other lawyer in the court. What do I really need here? You know, don't ask for a protracted date, which is all day. If it's the two litigants, you think the child may talk to the judge and maybe one or two fact witnesses. That may be a half day. You've got to really know what you need. You file a motion or a petition asking for what you need. You set out the grounds. Why is it so complicated? Why is it not a case that can go in 45 minutes or an hour and a half? And the judicial hearing sometimes will be a phone call set up between the judge and the two lawyers at 8:30 in the morning just to talk about it and see if the judge understands. You may come in and wait 3 hours before you get in front of a judge to tell the judge why it's protracted. But again, it's something that needs to be assessed early on in your case and file that motion as early as you can.
Yeah, and actually sometimes the motion will just be decided on the papers. So the last couple of motions for protracted I filed, I have not had to show up. I've just gotten an order granting my request and scheduling me before a judge.
And I think that comes with seasoning. I think that Judge Murphy does a lot of those. She's the administrative judge of family court. She knows who the honest players are and then the lawyers who aren't unnecessarily going to take time. And sometimes she reads the petition and she sees that the other side agrees and yet both lawyers are seasoned lawyers. She just signs off and sends it out.
But it is, as Lee said, it's super important to do it as soon as possible. So because of the timing of the court. So for example, I got a notice, I went through the custody hearing process, we got the regular date, but I knew I would need more than that. This just happened last month. And so I filed for a protracted listing, which has now been granted, but my hearing's now not scheduled until next spring. So they're already scheduling dates now in March and April. So the sooner you file it, the sooner you're going to get a date, which is not going to be a soon date, but it's better than waiting. If I had waited until January to file my motion for protracted, that's going to push me back into the summer or the fall. So it's another reason why you want to file as soon as possible, because otherwise you're, it's just going to take longer before a judge can actually address it.
It's your turn, Megan.
Okay, so consolidated case management. I love CCM when I'm handling a case that is just more than just one thing. So, when I have cases that involve divorce and custody and support, CCM means I'm going to have one judge for my case. Other counties do this by rule. I mean, Montgomery County always assigns one judge, one family, but because of our how many cases we have here in Philadelphia, we just don't have the freedom to do that. So if you are taking on a full case, or if you want to work with, if there's another lawyer perhaps handling the divorce and you're handling the custody, filing for CCM may be a really good avenue, because then it's one judge that gets to know the whole family, understands the nuances of what's going on, is handling the divorce side, is handling the discovery issues, is handling the support, and then also is handling the custody. And it also means everything you file goes to that judge. So if you're filing a petition to modify the custody, it goes to that judge. If you're filing an exceptions hearing, it goes to that judge. If you're filing expedited, it goes to that judge. So that judge handles everything involving that case.
And I like CCMs also in cases where you've got a very complicated custody case. Maybe you've got a child with an illness, or you've got something that you know that if you get in front of a different judge on every motion or every petition to modify, you're going to have to bring the same medical testimony in every time to educate the judge as to what is going on with this kid. But if a judge has CCM, then you only do that one time. Of course, you may have updates, but in complicated custody cases, CCM is great. And you can also, other than filing a motion, you can, once you get into the hearing with the judge, at the end of the hearing or during the hearing, and the judge begins to see the complicated nature of the case, you can ask the judge, would you agree to be the case manager of this case going forward? And many times judges will say yes, because they get it too. So again, it's not something to be abused, but it's really a wonderful tool in the right case.
Lee, have you actually filed for CCM just in a custody case? I've done what you just said in terms of ask the judge to keep it. I actually have never filed a motion just for a custody case.
I haven't either. And, generally complicated cases generally beget lawyers that have more experience than less experience, generally. And
Right.
a lot of times I'll say to the other lawyer, I'll say, Megan, this is really a CCM case. We really ought to ask, I keep using Judge Ford, but we really ought to ask Judge Ford if she'll keep this case.
Right.
And we agree, we'll go in and sometime during the presentation, we'll ask her if she will. And, if she sees the nature of the case, then she may very well say sure.
Yeah.
So expedited relief is an often abused, but can be very valuable petition. So remember, you've got three different types in general of petitions to be filed that it can affect a custody schedule. You've got a petition for custody, which is standard petition. You've got an emergency petition for custody, which is, and we'll talk more about that later, but we have an emergency, and then you have this expedited thing. And the expedited petition generally is a petition that can be filed or should be filed and I'll list a couple circumstances, Megan, and you can come in with others. For example, you've got a case that came out of a hearing officer without a custody order and one parent has no access. That's ripe for an expedited petition to get the client some access, not the access your client wants, but some access. So that's for expedited. Let's say that you've got an exchange location at a parent's house, pick up and drop off of the child, and the parent's paramour is now coming out of the house and threatening the other parent when they're picking up the child. You may need a different exchange location, which they may not agree to. That's ripe for an expedited custody petition. What isn't ripe for an expedited custody petition is trying to get a final order in a custody case. This is generally a very quick procedure. In fact, I remember when Judge McLaughlin was on the bench, she would tell us not to sit down. That's how quick it was. You went in, she swore in the witnesses, she looked at Megan, she said, "Why are you here?" Megan gave a literally 2-minute spiel. She looked at me and said to me, "What do you have to say?" I gave a 2-minute spiel. We had a little back and forth. We had no testimony, and she ruled on the expedited petition. And that's an expedited petition. You should be in and out in 10, 15 minutes, hypothetically. I'm not going to talk about exceptions because it doesn't matter for today. But expedited is that hybrid between the regular old petition to modify and the emergency for very isolated relief. Are you okay with
Which
that?
is why, which is why an underlying petition is required in this
Mhm.
case. So this a motion for expedited relief, as Lee said, is one specific little issue. So you need an underlying either a petition for contempt, petition to modify, or a custody complaint, because this petition is not to be about everything that you need to address. It's just about one thing that has to be decided quickly, and you need to explain why it has to be decided quickly before that you're actually listing. And so you do need that petition. It's also specific to Philly, so don't go try using this in other counties. This is something Philadelphia has done because of our backlog, and they recognize that there are issues that might have to be addressed before you actually get in front of a judge. So emergency custody petitions really have to be an emergency. It has to be about the child being in danger. It is not about no access. That is not an emergency custody. That, as Lee said, could be the subject of an expedited. You also need an underlying petition in an emergency custody here. When you file an emergency, you also need to file an underlying petition to modify or custody complaint. But it has to be emergent, right? So a parent might have disappeared, or maybe they're drinking a lot, or they got a DUI, or there's like there's a reason because the child is in danger that there has to be a change in the custody order now, and you can't wait. And this is handled right away. So if you file an emergency petition, it will be dealt with and addressed on that day. It goes first to the custody hearing officer who reviews it. You have to be available. You and your client should be available at that time if he wants to bring you in. And then if there's a decision that an emergency order is appropriate, it gets sent to the judge on the same day. So an emergency is an emergency is an emergency. It can also be denied if it's not found to be an emergency, and you don't get to see a hearing officer and you don't get to see a judge. But again, that's another reason why they want an underlying petition, so that there's actually a request out there to address what you want to address. Anything to add to that, Lee?
No, it is rarely granted in Philadelphia. So
Right,
don't be
rarely.
surprised if a client calls you and says, "I just filed an emergency and it was denied," you can talk to them about it, but it's done already. It's time to move on. It's very, very, very limited relief.
Oh,
Yeah,
and-
if you can, and what we normally do is petition is done. I generally get there with my client early the following morning. Don't go in the afternoon. It's just not enough time in the day unless it's truly like the client is leaving for Brazil. I mean, that's a whole different story. But the petition's done, ready to go. The day before we go in the morning. If my client has access to an address or we can fax it, we can email it, an email address, whatever. Let the other side know. First question you're going to be asked when you get there is, did you tell the other side? So you might as well let them know. And if they have an attorney, it's simple. Just email to them, tell them that you're going to be there, her that you're going to be there the next morning at 9 o'clock. Have a conversation. Send it to them the petition. It's not a secret. And then at the conclusion of the hearing, if the hearing officer believes that it's an emergency, then you, like Megan said, a judge is going to sign off on it. Sometimes they'll take you down and talk to the judge if the judge asks for you to do that. And this is only a temporary order, and there'll be a full hearing scheduled. It says in approximately 10 days. That's a goal, especially if the opposing party wasn't there. So don't hesitate to file in the right case, but by filing them, you're going to learn what the right case is.
Yeah. All right, contempt petitions. So a party is in contempt of a custody order if there is willful failure to follow that order. You can file a contempt. I mean, you can have a contempt about anything, right? They're not following the phone calls or the FaceTime, or they're showing up at a wrong time, or they're not. You can file a contempt. I'm going to tell you right now, and I think this is on one of our slides. Don't file a contempt without also filing modification if you're seeking to modify the order. Modification of an order is not a remedy for contempt. The remedies for contempt are money, attorney's fees, sanctions, and if you miss custodial time, you can get some makeup time. But if there's a problem with your order, if you want a modification of the order because someone is constantly, for example, not showing up on time to do an exchange, then you want a modification. You want to change it from a 4 o'clock exchange to a 6 o'clock exchange. And a party's only going to be able to found in contempt if they're in willful non-compliance. So, for example, if a party can't get to a 4 o'clock exchange because they don't get out of work until 5 o'clock, they're not going to be found in willful non-compliance. Fix your order. And that's the problem I have with a lot of contempts. Is it really is about the failure of the order. The order isn't clear enough. The parties did not have the same understanding when they agreed to it, and it's sometimes just reaching out to the other side, to the other lawyer, and trying to work on the order will solve the issue that your client wants to see contempt about.
And even if there is contempt, you're going to be dissatisfied as the filing attorney in most cases with the remedy that comes about, because most judges, unless the contempt is horrific, most judges are going to slap of the hand on the other litigant the first time. There's one judge here, a relatively new judge, who takes these very seriously and can assess counsel fees on the first petition, but it's very unusual. So like Megan said, look at the global order as it impacts the parties. Contempt is very dissatisfying unless you're going to try and build a record and you think there's going to be numerous contempts because this person just doesn't care what the order says. Different story, but you've got to counsel your client to be patient, and this is going to take several filings and several findings of contempt before anything meaningful happens. It's a long game.
Yeah. But contempts do, if you have an underlying filed, sometimes the hearing officer they'll consolidate the contempt with the underlying, but they're to be scheduled in front of judges. But just to try, and this again goes back to what I was saying about contempts. If you file an underlying modification because you know you can't get modification with contempt, and they get consolidated before a hearing officer is going to do exactly what I suggested do. Figure out how a modification to the order and how changing the order could also resolve the contempt. And so the hearing officer is going to, work their let's try to resolve it issue to try to resolve both. But if it doesn't get resolved, it will go to a judge. So with a contempt, you get enforcement of the order, but depending on what it could look different. All that when a judge is talking about, when the issue is someone's not showing up on time, what the heck is a judge going to do other than tell them to show up on time? They're not going to go grab and walk them to the exchange location. So that's why we're saying, like, the remedies that are available for contempts, you have to really think about what's realistic. And yes, judges can order sanctions. I have never, maybe once, I'm trying to think if I've ever seen a judge jail someone or put them in the holding cell downstairs for contempt of custody. Maybe once.
So I had a case once against one of the sheriffs in the building. It was one of the parents, and this sheriff had routinely violated the order and acted crazy at custody exchanges, and there were several contempts. And eventually the sheriff was thrown in jail, which is kind of unusual for a sheriff to
Wow.
be thrown in jail. But it's a long game, Megan. I mean, you're not going to get that kind of
right.
relief on the first, second, or third petition, somebody thrown in jail. And generally, a judge will put somebody in the holding cell in the family court building to just try and straighten their brain out. You know, they're not sending them away for months at a time. It's just like, you're in jail now. This is unpleasant. Are you going to follow the order, or are we going to get more serious? So there you go. It's all, the contempt is exactly what Megan said, what the remedies are. And unless you've got a long game going, it's going to be very unsatisfying for your client.
Right. And I agree. And in the cases that VIP is taking, you're not working the long game, right? You're trying to help this client with what they're dealing with right now. So you want to work with them to try to fix what the problem is. So, I was just trying to think of some of the outside of the box thinking becomes very helpful. And I recognize that when you don't do this regularly every day for your living, it might be hard to think about it. So I'm going to say mentor again, because for example, I have a client who the other side was constantly in contempt because they wouldn't show up for their custodial time. That's very frustrating to take a child to an exchange location and have the other side not show up. It's also emotionally damaging for the child. So instead of filing a contempt, which would have done no good, I filed a modification and the order was modified such that the other parent has to text the custodial parent 2 days ahead of time if they're going to show up or not. And if they don't text, or if they say they're not going to show up, the other parent doesn't have the obligation of showing up. So this child is not placed in this situation to have the parent not appear. And the custodial parent doesn't have to waste their time going to an exchange if the other parent hasn't indicated they're going to be there. That was a much better remedy than filing a contempt.
And that's a very creative application of experience in this case. And you can be creative in your cases. It isn't boilerplate. And that was very good thinking on Megan's part. And it was very practical. And that's good lawyering. So don't be afraid to be creative.
Exactly. Okay.
So, unless it's a very unusual situation, maybe involving abuse of a child or just something very unusual, in front of a hearing officer, your child is not going to testify, is not going to appear, is not going to be involved. So don't bring your child to court for a hearing officer case. If you do want to request it, you need to do it in writing ahead of time, communicate it to the court, to the custody hearing officer, and you got to let the other side know you've requested it. Because sometimes a lawyer will request that a child appear, and I'll get a copy of the letter, and I'll write a letter objecting to it. So now that both those letters are in front of the hearing officer, but you got to do that letter right away, because they may decide that within the afternoon or the next morning of the day they receive the letter. As far as a judge is concerned, most of the notices we get right now say children will not attend the hearing unless the lawyers or the parties are otherwise notified. Megan made a good point before about calling the court chambers. Don't be afraid to do that. There's a law clerk. Every judge has a law clerk. You call the chambers number. You say, "Hi, I'm Lee Schwartz. I'm a lawyer in town. Is the judge's law clerk available?" Happy to talk to you. Get on the phone. I have a hearing in front of Judge Smith in 14 days. Does Judge Smith want the kid there? Most times the clerk will say no, or they'll say, "I'll talk to Judge Smith and I'll get back to you." And then So don't be afraid to call. We call for all different reasons to find out information. And I've never, well, that's not true. I generally do not encounter any problem getting in touch with the court staff. You should not be reluctant to do that.
Now, I will say with regard to children, one of the factors is the preference of a child. So a judge, when making like the full custody picture decision, is obligated to have a conversation with the child, depending on the child's age. I mean, the child really needs to be at an age that they know the difference between the truth and a lie, that they can express their opinion in a mature way. So if you have the case where the judge is expected to do a full, complete resolution, and your order is either silent or you're not clear, I would contact the court. I would probably put it in writing, so that the other side is copied on it. And I regularly ask for the child to come at a different time. I do that. Not everybody does it, but I do that because the stress of being in the court when both parties are there and when the judge is trying to hear the whole case, sometimes I think really does impact the emotional well-being of the child. So I will, if I can, try to make arrangements for the judge to interview a child at a different time. I certainly don't want the child sitting there all day while testimony is being taken and like sitting in the waiting room and like being bored when they should be in school. So if you have any questions, just contact the judge's chambers. Also, if a judge is interviewing a child, you have the ability to draft your own questions. I mean, every judge has a different procedure, and you can check with that judge. I will regularly draft questions that I would like the judge to review and ask the child in some fashion, right? I mean, they use their own words, they pull it out the way they want, but there are things that I know I want to ask the judge because I'm expecting that the judge is going to respond a certain way. So you can absolutely submit questions to the judge. And the other thing is, it's possible that judges talk to the children without any attorneys present. So attorneys can waive their presence. I regularly do that unless there's a question about coaching. And so it would be the judge, the child, and their court reporter, or a court personnel in the room with the child. And that's the only people that are going to be present. Different judges interview children differently. There are some judges that are really wonderful at interviewing children and some judges that have difficulty interviewing children. Lee, anything to add?
Nope, that was beautiful.
Okay.
Continuances, those need to be requested for practical reasons. You need to request those as early on in the case as you can. Many times I'll get a hearing notice for a case in February and I'm going to be away, be on vacation.
Yep.
And I'll call Megan right away and say, yo, Meg, I'm going to be on vacation. Any objection? Lawyers do not generally object to other lawyers' requests for continuances for vacation. It's bad form. Why is that? Because you're going to want to request a vacation one day. And if I'm on the other side, I'm going to say, remember the Smith case? So, and you explain to your client that we just don't do that. Now, there's reasons to object if there's an emergent, important reason to do that. But I would explain that to Megan. She would call me an SOB. And then I would let the judge know anyway. And always when you request a continuance, you want to attempt to find out what the other side's position is, because the first question the judge is going to ask you through the chambers is, what does Megan say about it, Mr. Schwartz? So I want to call Megan and tell her, and generally Megan says okay. If she objects, I tell them that they object. And Megan, then what you're going to do, as soon as you know the other side is going to request a continuance, don't wait for the time to get the letter to write your objection. Write your letter that moment, and as soon as you get the letter from Megan saying this, being sent to the court, you're being copied on it, send your letter in right away, because you don't know how fast they're going to respond to it.
Right.
And there's emergencies. People get sick. People unfortunately get into car accidents, whatever.
Yeah.
Contact the court if you need a continuance. All judges treat them differently. Some are more likely to give a continuance than others. Judges understand vacations. And unless you're a lawyer that every time you get a hearing date, you have a vacation, and the judge starts saying, well, look at this person. Every time there's a hearing, they want a continuance. Be honest with it. Don't abuse it. I'm sure you won't. But continuances are possible. Just do them as early as possible. And the practical reason is, if I request it right away because my schedule's blocked, remember how long it takes to get a new date in Philadelphia County. If I request it right away, your next date may be 3 or 4 weeks out from that prior date if you request it right away. If you wait until 3 weeks beforehand, you may be 4 months out to get in front of the judge.
So other types of motions that you can follow. So first of all, there is no discovery in custody cases. There's no right to discovery. I have never filed a petition for discovery. I mean, if there's like a specific issue, for example, someone's mental health, those I have filed motions to have a mental health assessment, which used to be done. You used to have an option to do it at the court. We have not been able to fill those empty psychiatrist positions. So at this point, if you are seeking a mental health assessment of the other side, you have to get that done on your own, and it can be expensive. It's not really something that most VIP clients are able to do. There's also custody evaluations. Again, not a lot of VIP clients can't afford those. They are very expensive, but that is where you have a professional who's like coming into the homes, meeting with the children, observing the children with the parents, getting background information, talking to witnesses, and making a recommendation for custody. There are home studies, which is done by an employee of the court system, and that is so someone from the court system will go out and see the home of one of the parents. If there are questions about whether the home is safe, whether it's there's enough food in the house, I mean, if there's any kind of issues like that, you can file a request for a home study. You can file for counseling. I have done that many times, especially post-COVID. Oh my gosh. Filing a motion for special relief, seeking for the child to be enrolled in counseling so that the child can have a therapist. When you do that, keep in mind, do you want the therapist to be able to testify or not? Because that always becomes an issue later. So this is a perfect example of the clearer you are up front, the better it's going to be for you in the future. Personally, I think children should be able to have a counselor that they can talk to, that they're not worried about walking into court, so that they can express themselves and be completely free and open and honest in those sessions. But those are just some of the few types of motions you can file. I'm trying to think of some other. School, you don't have to do a petition to modify. If it's just a school issue, you can file a motion for special relief to address where the child will go to school. And then that goes directly to a judge. A medical issue. I mean, so really motions can be very specific, right? If you have something specific you want to address that doesn't fit into the expedited kind of role, you can file a motion and then it goes right to a judge, and you're not filing a petition to modify that starts with the hearing officer. So if there's like a specific core issue that you need to deal with in your custody case, you can do that through a motion.
So agreements. Judge love agreements. Lee Schwartz loves agreements, and Megan Watson loves agreements.
Mm-hmm.
Good lawyers use their best efforts to make agreements. Good lawyers counsel their clients that even if the agreement isn't perfect or what they necessarily were dreaming of, there's a big difference between having an agreement and the certainty of having an agreement versus letting the black robe decide your custody case. So as hard as you're working and representing your client, it's best that a lawyer work equally as hard in trying to make an agreement. Sometimes you can't. It's impossible. Both parties want primary and there's no movement. Okay, we're going to have a trial. But this can be done at any stage of the proceeding. Megan and I work on it together until it shows to be an impossibility in a case. And I counsel my client, I beat them over the head with a stick and tell them it's so much better to have an agreement that you can live with than just letting a judge decide. Because a judge may not decide it the way your client wants it or the other client wants it. Judges decide what judges decide. But if you have an agreement, lawyers will draft a stipulation, which is an agreement, signed by the parties, signed by the lawyers, present it to the court, and it ends the custody matter at that point in time. Remember, custody is never a permanent or final order. It's always modifiable. So that's something to use in your tool chest in talking to your client, that you may not get the order exactly what you want today, but we can always go back later if we need to. It may not be part of a VIP case, but that's just custody in general. But agreements are good.
And even if you can't get in a final agreement. Like, I find it's helpful if earlier on, right, maybe around the time of the hearing officer, if you can get a temporary agreement in place, a lot of times parties, they live with that temporary agreement until they're going to go to the judge, and they find that it works. And then that temporary agreement becomes a final order because they've been operating under it. It makes sense for the kids. It makes sense for them. So even if, like, at the beginning stage, you can just get your client and the other side to an agreement. Okay, we're going to try this for now. Usually that helps then lead to a final resolution, and you don't end up having to try the whole case.
Let me give you the best tip of the day. Megan and I are very good friends. Megan and I know everything about our families and what our kids are doing and what our husbands are doing and what our wives are doing. Your relationship with lawyers is very important. And I never, ever raise my voice to Megan. I never treat her respectfully, because when this case is over, I'm going to have another case with Megan, and I'm going to have another case with Megan, and I'm going to have another case. And she knows that I'm honest, that I never tell her a misstatement, that I aggressively represent my client, that I beat the hell out of her in court and she beats the hell out of me, and then we go have dinner.
Yep.
So that's the attitude you need to have in these cases. You need to represent your client zealously, and you need to treat your opponent attorney with respect. And if you keep those two things in mind, you'll have a very successful legal career, because we know who we trust and who we don't trust. And you want to be in the trust side.
Yeah, totally agree. Okay. So communicating with your clients, it's obviously super, super important to be in communication. I mean, so whether, we all have our own preferences for how to communicate. Now, I will tell you, some VIP clients might not be able to communicate by email. So you might have to adjust how your normal communication is. I do a lot of emails. I'm sure Lee does too, right? We work a lot off of our computer, but if a client's unable to communicate that way, then you need to figure out a way that works. Don't wait to meet the client until the day you walk in. I mean, your obligation to the client is to be prepared. So you need to have that original conversation. You should be talking about, do we need witnesses? You should have had a conversation with them about, did this need to be protracted or semi-protracted? What are the actual issues here? Potentially reaching out to the other side and trying to reach a settlement. Just because it's a client that's not paying, you still owe the same duty to that client as you would any other client. Managing client expectations, this is sometimes a hard thing to do. And I understand that it's hard, probably a little bit harder for people who aren't regularly in family court. Lee and I can tell you off the top of our heads what to expect in front of what judge any day of the week, right? But when you're not there, we understand that it's a little bit more difficult. Again, feel free to reach out to us. I'm in front of Judge Christensen. What should I expect? What should I be telling my client? Happy to answer those questions. But if your client is saying to you, I want sole physical and legal custody because I don't like the fact that the other side drives a convertible BMW and drives too fast, clearly you know how to manage those expectations, because that's a ridiculous expectation, right? So on some level, you need to have your client prepared for what's going to happen and what they should expect to be a reasonable outcome of their hearing. In terms of prepping clients for hearings, again, back to what I said, you should be having regular conversations with them. Throughout this training, we said to you, you need to find out the facts. You need to find out who's in their house. You need to find out what are the specific issues that they're dealing with. What are their specific concerns? What is it that they think? What is it that they want their order to look like? What issues are they having, and how would they like to resolve those issues? What's going on with the children? Do the children have special needs? The more time you spend talking to them, the more information you get. And then you can prepare yourself, and then you can prepare your clients. I hope we didn't scare you away. Take a case.
Thank you, Megan and Lee, for that awesome training. Megan, go ahead.
No, I was just going to say, we get that it's daunting to think about taking family law cases. Like, we understand that, right? A lot of people are scared to do that. You've heard that so I would say if you're nervous about it, take it at the custody hearing officer level, right? You've heard that's not the final level, right? There's always going to be a judge date after that. So if you're scared about it, try that level first, because it's not the be all end all, and you can do some good for the client. Maybe you get a settlement and an agreement, which is fantastic. You have just then met the needs of the child and the family in that case. If you come in at that level and are able to work with them and reach resolution, even if it's partial resolution or full resolution. So please consider taking cases. There's such a need out there.
And pro bono work is the highest calling. You know, Megan and I have established law firms. We make a decent living, but the greatest work you can do is for people who don't have the ability to hire a lawyer, because just having your warm body next to that litigant in a courtroom or in a hearing changes the playing field. Even if you feel like you don't know what you're doing, you'll figure it out. But Megan and I both marvel at public interest lawyers and what they do and what they've given up to do what they do. And it's the same in pro bono work. Listen, for every hour Megan uses in a pro bono case, that's an hour less than she can bill. But she understands the value, and we understand the value of you. So listen, I ain't the smartest tool in the toolbox, let me tell you that. But you can do it. Get involved, get experience. There's no way to feel comfortable until you have experience. It's not going to happen on day one, but just get in there and do it. And you'll just see that it can be done and that you can do it. And you'll see the value. These folks are going to be so grateful that you've been there with them. So just give it a shot.
Thank you for that. Denise, do we have any additional questions in the chat from our attendees?
We don't. Lee was manning it beside me, so we're all up, taken care of.
Awesome. Well, thank you again for everyone who's in attendance. We're going to send out a few follow-up materials later this week. And as always, if you have any questions, you're welcome to reach out to me and Denise. And if you're interested in taking a case, you can either speak directly to me or Denise, or you can look at the available cases on VIP's website. Thanks, everyone.
Thank you all. Great seeing you.